These are part-heard appeals in the matter of Orsted West of Duddon Sands Ltd and the Commission for HMRC.
Mr. Jones. My Lords, I had finished yesterday looking at the authorities on ground 2 that I wanted to show you, Lordships. Taking it from there, so far as concerns the application of those principles to our fact, your Lordships will recall from the case law that at least the working assumption, the initial presumption, is that money spent on the acquisition of an asset, which is capital, should itself be regarded as capital expenditure. And consistently with their case in relation to section 11.4, that, in essence, is the basis on which the companies contend that the expenditure in issue was capital expenditure, but it was expenditure which qualified for allowances. The money was spent on the acquisition of a wind farm, which is a capital asset, in the form of design on its layout and construction and installation of its component parts. And as was recognised by the FTT, the Upper Tribunal and the Court of Appeal in Samarkand, there is in substance no conceptual difference between the concept of expenditure on the acquisition of an asset and expenditure on the provision of one. But if it wasn't expenditure on the acquisition of the wind farm and its component parts, then it is difficult in my submission to see on what other asset, capital asset, the money could properly be said to have been spent. If on HMRC's case it is right that the expenditure in question really was too remote from the plant, then on what basis is it capital rather than revenue expenditure?
Well, the answer might be that the end in sight was still the same, namely to lay out expenditure in the hope of acquiring a capital asset as a profitable part of your trade in due course. But I mean, the mere fact you fail one of the tests in the capital allowance legislation, it doesn't follow from that the expenditure in question is suddenly turned from capital expenditure into revenue.
That's entirely right, my Lord, with respect. The difficulty with the FTT's conclusion on this, which I'll show you, Lordships, in a moment, is that it appears to treat the submission as though it is a binary question. If you're not in section 11, then you must be revenue. That is not the substance of the point. The substance of the point is that the primary case is that this is expenditure on the acquisition of a wind farm, which is capital expenditure and a capital asset. If that's right, then conceptually that must be expenditure on the provision of plant. If it is not expenditure on the provision of plant, i.e. on the acquisition of a capital asset, then on what capital asset was it spent? And there is no other basis on which, in my submission, it can be considered capital expenditure.
I mean, on the face of it, the point would have to turn on the meaning of on the provision of, wouldn't it? I mean, you say, well, on this thesis, it would be capital expenditure because it was referable to the wind farm, which is the asset we're concerned with for capital allowance purposes. So if it is capital in this context, but doesn't qualify for a capital allowance in relation to plant, it would have to be because it wasn't on the provision of the plant, even though it was in some sense referable to the plant.
Effectively, it would be because on the basis of the principles and on the capital revenue divide, it would not be on the acquisition of a capital asset. Because we're not in a world where there's any other principle that's said to be applicable here. It's not to divest, the companies weren't divesting themselves of an onerous capital asset, for example, or some of the other instances like in Tucker and Granada where there's money expended to modify a capital asset. It seems that the only principle in play is the principle that it's capital because you've acquired a capital asset. But if that is so, then the answer on the first ground should be that allowances are available. If that is not so, then it is difficult to see, as Lord Wilberforce observed in the Caron case, it's difficult to see what other conclusion there could be if there is no capital asset on which this is said to have been spent. It is not, the submission to be clear, is not that it is a binary question, so that if you're not in allowances territory, you must be in revenue territory. It is, I hope, clear that it is not as crude as that. It's that when one gets to the capital revenue divide and one looks at the principles, the principle in play is the one where it's capital because you've acquired a capital asset. And there is no conceptual difference then in substance between the provision of a capital asset and the acquisition of a capital asset. That, in a nutshell, is the company's alternative case. And as I say, if the revenue are right that it really is too remote from the plant, then it's too remote from the capital asset.
Well, that seems to me, with respect, simply not to follow. I mean, there are separate tests in different contexts. And the starting point for capital allowances is that the expenditure has to be capital. I mean, that's actually there in Section 11.
That's right.
So it can't, by definition, if it's revenue expenditure, it can't qualify for capital allowances, just for that reason, if no other. But then, assuming for whatever reason your appeal doesn't succeed in relation to the plant, well, we then end up in a situation where allowances have been granted for a great deal of the material which one finds comprising the wind farm, and indeed for quite a lot of the earlier expenditure, which has not been the subject, that hasn't been appealed for one reason or another. And that's that so far as capital allowances is concerned. But if you're then now turning it all on its head, so to speak, and saying, well, although the whole capital allowance case is predicated on the expenditure being of capital rather than income, nevertheless, it must still be treated as a revenue expenditure in relation to disputed items. And I just don't really see the connection, logically, between the two propositions. If you failed on the capital allowances, you then have a separate contention that it was actually revenue expenditure, which is flat contradictory to your case on capital allowances. But stranger things have happened.
Well, with respect, my lord, it's not contradictory in the sense that if the expenditure fails to qualify for allowances on the first ground, it must be because it was not expenditure on the provision of plant. But if it was not expenditure on the provision of plant, then when one gets to the case law on the capital revenue divide, and one looks at the working principle about acquisition of capital assets, then it would seem to follow from the conclusion of the first point that it is not expenditure on the acquisition of a capital asset.
I'm afraid I don't really see the necessary logic in that submission. Although it seems, I mean, supposing we were to adopt a strict and narrow approach to the issue of provision in line with a possible interpretation of what Lord Wilberforce said in Bernardeco and maybe some other authorities as well. That would, I mean, if we were going down that route, then your capital allowance claim would fail. But just because, and it would fail because, it may be said, we'd adopted or reiterated a strict approach to that part of the learning on the subject. But why actually follow? But when we go to the separate question, whether it's capital or income in a general sense, which again is a binary question, it has to be one or the other, then I don't see any contradiction in saying that even though the expenditure hasn't qualified for capital allowances, it is nevertheless all directed ultimately at the acquisition of the wind farm, which stamps it as capital all over.
Well, the principle that's enunciated in the case law on that score is that it would be capital expenditure because it is expenditure on the acquisition of a capital asset.
Well, or directed towards the acquisition of it. It doesn't have to be on it in a kind of capital allowance sense.
Well, on the subject of whether it's on, perhaps I can just show your lordships what the FTT had said about this aspect of the appeal. The FTT dealt with it briefly. It starts at paragraph 219 in its decision. Which is internal page 60. It's core page 480. And at 222 and 223, the tribunal summarise submissions, and then at 224, it set out its conclusion, deciding the point against the companies, and concluding that there was a logical fallacy in the company's position. I found the expenditure on some of the studies not to have been on the provision of either the generation assets or the single item of plant, or the wind turbines and array cables as items of plant. But I've done so on the basis of the highly specific wording that appears in the capital allowances legislation. I've not done so on the basis that the foregoing assets are not capital assets. It is clear to me that the expenditure on the studies is expenditure on or in respect of assets which are capital in nature, namely the assets identified in 216 above. So there are identifiable capital assets on which the expenditure has been incurred. Now, the reference to 216, I think, should be a reference to 222, because 216 doesn't contain a list of assets, but 222 does. And in 222, the tribunal said it was summarising a submission that I had made, saying that the wind farm and the wind turbines are capital assets, as too are the studies, the leases, the agreements for lease, the consents, and other assets which the appellants have acquired in these projects. Now, with respect to the FTT, that was not actually a submission I had made, or that does not actually capture the submission that I had made accurately. I had submitted that the wind farm and its components were capital assets. I hadn't argued that other items were capital assets. Now, it was on that basis then that the FTT concluded that the expenditure in question was expenditure on items of a capital nature, and so is not deductible.
Or in respect of, is the wording they use.
Well, on or in respect of. I'll come to in respect of in a minute. And it's not clear from the tribunal's conclusion whether it considered the expenditure was on or in respect of all of the items that it names in 222, or just some of them. Now, in relation to in respect of, it doesn't automatically follow, as a matter of law, that expenditure in respect of, or indeed even on, a capital asset is capital expenditure. For example, and this was touched on in some of the case law that we looked at yesterday, it's recognised that expenditure incurred on the maintenance of a capital asset is actually generally deductible as revenue expenditure. I've referred in my skeleton to Odeon, Associated Theatres and Jones, which makes that clear. But if, as is the company's primary position, the expenditure in question was on the wind farm, on the acquisition of the wind farm, then it was qualifying. If it was not on that, then what was it on? The FTT has listed some other items, but of those items, in my submission, only the leases and possibly the agreements for lease could be said to be capital assets. And as regards those, the focus of the expenditure was on the wind farm and the physical impact it would have on the environment, and the impact that the environment would have on it. The focus of the expenditure was not on a lease or an agreement for lease, and one can contrast Tucker and Granada that we looked at the close of yesterday, where the focus of the expenditure there was a change in the terms of the lease held by the taxpayer. The expenditure was consideration for that change to the terms of that asset.
Not that this matters, but just so I've got it clear in my own mind, when was the agreement for a lease concluded in each case? When was a lease concluded in each case?
I don't have those dates.
I don't mean precisely the dates. I mean when in the structure of a transaction or a development.
I think I'm right to say it's relatively early on in the process.
Did you enter into the actual lease?
Well, I'd have to go back and remind myself exactly of the dates rather than give the court incorrect timeline. So the FTT finds the facts at 19.
It's quite a useful chronology of tab 8, actually.
Probably.
And on page 107, I'm seeing that in relation to Gunfleet Sands Phase 1, the agreement for lease was on the 4th of April 2003. And it was then followed by reconnaissance, geotechnical studies, and so forth, applications for other consents. So it was quite an early stage. And the FID didn't come until December 2006. So 3.5 years later.
Yes, so there's also a description of the steps in the FTT's decision at 19 onwards. And looking at that, there's a bid made to the Crown, it's para 20. And then at 22, if the bid is accepted, then Orsted is granted an agreement for lease by the Crown Estate over the relevant site. And it takes approximately 5 to 6 years from being granted an agreement for lease to obtain the final investment decision, and approximately 8 to 9 years from obtaining that agreement to lease to the commissioning of the wind farm.
This really is complete red herring, but just so I'm clear in my own mind, I don't see in the chronology a reference to that. Obviously, the lease is actually executed in 2008 in this particular case.
Yes, I think the timings can differ.
Yes.
But there's
an early agreement for a lease, and then
yes,
the final lease is granted sometime after
subsequently.
the bid.
That's yes, I think that's right. Yeah, so the description of the steps runs through to paragraph 33 of the FTT's decision, which outlines the rough timeline. There are more detailed chronologies, as my lord has indicated. There's also an agreed statement of facts, which sets out several of these steps. Just on the point about the lease, it's also right to say that the metocean studies and the geotechnical and geophysical surveys have nothing at all to do with any consent process or permissions or the lease. That is solely to gather technical data to inform the design and fabrication of the component parts of the wind farm. So in my submission, there is no tenable basis to conclude that that is expenditure on anything other than the wind farm. And if it's not on the wind farm, bearing in mind that on is a much tighter nexus than on the provision of. If it's not that, then it is very difficult in my submission to see how it could qualify as capital in the first place.
But I mean, we're not construing a statutory test here, are we? We're just looking at the common law of tax as it is developed in the case law on how you distinguish capital from income.
That absolutely is the case, my lord. But the principle in play is the acquisition of a capital asset.
Well, anyway, we've debated this point.
Your lordships have my submission from that. The Upper Tribunal dealt with this point with even more brevity than the FTT did. It addressed the issue at 183 to 186 of its decision. It concluded at 186 that the FTT was right to reject the taxpayer's case. It was open to find that the expenditure was not on the provision of plant or machinery, yet still conclude the expenditure was capital in nature. And then a little lower down in that paragraph, HMRC are right to point out that the division between revenue and capital expenditure turns on its own test, which is different to the on the provision of plant or machinery test in section 11.4. While the term test does not quite capture the approach by which an answer is reached to the capital revenue question, the key point is that the questions and ensuing analysis in respect of each are different. Well, in a sense, I don't disagree with that as a proposition. But what the Upper Tribunal doesn't do is go on to analyse the capital revenue divide, which is a question of law, So it's not really a question of whether it was open to the FTT to reach that conclusion. It was a question of whether it was correct in law to reach that conclusion.
Yes, I think that's rather what I had in mind when I was referring yesterday to the importance of that distinction, which is often overlooked.
Yes, and although Centrica is obviously a very recent statement of that point, it is not the first time that point has been made, that it is a question of law.
Well, Beecham and Woolworths was 1992, and it was really decided the point conclusively, because that was a case where the Court of Appeal had said it was a kind of factual degree question that could only be overturned on Edwards and Bairstow grounds. And that was then decisively overturned in the House of Lords.
Yeah, so it wasn't a question of whether it was simply open to the FTT, it was actually something that was due its own legal analysis. The Upper Tribunal doesn't carry that out.
What about the specific example which the Upper Tribunal then gives in the penultimate sentence, paragraph 186?
Of the finance costs on Benedetto?
Yes.
Yes. In relation to that, what Benedetto acquired was capital. It acquired capital that it could expend then on the oil rig. So if one is looking for something akin to a capital asset, it's the loan.
But that does illustrate the point that you can fail to get a capital allowance and still not be entitled to a revenue deduction because the expenditure isn't on the provision of the asset.
Yes, I accept that. What I'd hope is clear is that I don't say that it must be one or the other. There is room in between the two.
Yeah.
That is absolutely clear. But in applying the principles in this case, rather like in the Caron case, if there is not a capital asset that can be identified in respect of which this could be said to be on, or on the acquisition of, then it is difficult to see how it qualifies as capital in my submission. Subject to any other questions that you might have on that, I've moved to ground 3.
Just before you do, well, it's my mind and irrelevantly, this is going back to the earlier grounds. When you were building your wind farms, you bought in the foundations, at least.
Yes, do you mean in the sense that they are fabricated by a third party?
Exactly.
Yes, I think that I'll just check, but I believe that is right.
Plainly, you will have incurred professional fees in relation to that.
In terms of the construction of it?
Well, in terms of entering into the contracts, for example. You will need to enter into contracts with the manufacturers, and I dare say that's a significant amount of work because they're bespoke items.
Yes.
What's the position in relation to those costs?
If I may just turn my back for a moment. As far as I can say, the revenue have accepted that that expenditure qualifies.
Yes.
I mean, they have indeed accepted that expenditure on negotiating the charter party for the installation vessel qualifies, which is a point that's referred to by the Upper Tribunal below. And the Upper Tribunal, and as part of the taxpayers' argument, they have advanced the point that there is something of an inconsistency in the way the revenue have approached these different expenses, because they have allowed, for example, negotiation of charter parties, but not the costs of design to fabricate the foundations, which seems like a rather odd distinction to draw. The Upper Tribunal's answer to that is, well, that's as may be, but that was what the revenue had agreed to, and it doesn't colour our analysis.
Yeah. Yeah, thank you very much.
So ground 3 concerns whether amounts of qualifying expenditure in the pools of qualifying expenditure that were claimed by 3 of the appellants in their tax returns are to be treated as being conclusively determined for the purposes of paragraph 88 of Schedule 18 to the Finance Act 1998. The appellants who are concerned with this ground are all but Orsted west of Duddon Sands. And the reason for that, as your lordships may have gathered, is that in relation to the other three appellants, when the revenue closed their inquiries into their corporation tax returns, they amended the amounts of the writing down allowances in their tax returns. And I'll show you an example of the return so your lordships can see this in the boxes. They amended that amount, but did not touch the box which contains the claim for the total amount of pool expenditure. In relation to west of Duddon Sands, a different officer took a different approach and did amend the amount of qualifying expenditure in the pool in that company's returns. Now the revenue accept that that's a mistake, that's been recognised as having been an error. The question is whether that can be corrected, in essence. The relevant facts are, as found by the FTT in paragraph 226, they are summarised in the Upper Tribunal's decision at paragraph 191.
So we should look at that or not?
If your lordships wouldn't mind just turning to that. It's dealt with quite briefly.
Well, this is in the Upper Tribunal.
In the Upper Tribunal, my lord, 191.
Thank you.
It's internal page 34.
Yeah.
And this paragraph just summarises findings that were made by the FTT at 226. So there's slightly more detailed findings in the FTT's decision, but for the purposes of argument, this summary should suffice. And the punchline of the summary is at 191 sub 5, as I said, the closure notices adjusted the writing down allowances by the amount of the development costs for which those appellants claimed qualified capital allowances, and did not amend the amount of qualifying expenditure that was claimed by those appellants. And just to illustrate that by reference to a return of one of the affected appellants, if your lordships have the supplementary bundle, and turn to tab 10, which is page 186. Your lordship should, I hope, have a company tax return form, which is for Gunfleet Sands II, and is for the period which runs the calendar year to the end of 2009. And just working through the return, there are various boxes within it that cover various items. And if your lordships turn to page 191, there's a section that's headed Information about Capital Allowances and Balancing Charges. And there is a box, which is box number 107, which is the main pool of machinery and plant. And that has a figure of 9.9 million. Now that is the figure of the writing down allowance, because that's the charge and allowance included in the calculation of trading profits or losses. See the subheading just above that set of boxes. And at the bottom of that page, there's a heading Qualifying Expenditure. And box 121, which is the final box on that page, is the total amount of expenditure in the pool. which is a figure of 134 million. So what the revenue did at the conclusion of their inquiries in relation to all but one of the appellants was to reduce the amount of the writing down allowance, which is the figure in box 107, but made no change, no amendment to the figure in box 121. And for your lordship's note, there are findings as to the amounts claimed in the pool and the writing down allowances in the FTT's decision at paragraph 93. And there is also a table in the Statement of Agreed Facts, which is Supplementary Bundle Tab 1, page 16, which sets out the figures.
It seems to be common ground that a mistake was made, and also that nobody was confused by it and knew perfectly well what the revenue meant to do.
I think that is fair.
If that is so, why can one not deal with the matter simply as a question of construction? I mean, there are many contexts where an obvious mistake is made in a document, and one can just construe it as meaning what everyone understood and meant it to say, without any more ado. Why can't one adopt that simple kind of approach here?
Because it is also clear that the revenue did not amend the box 121 figure. So the revenue had intended to do that, and in fact they did not.
I see. So
that's also common ground.
They left it untouched. In other words.
That's right. Yes. Now, the question at the heart of this issue in my submission is whether there exists within the suite of statutory powers that are conferred upon the tribunal a power to amend a part of the return that HMRC did not themselves amend.
I mean, going back to my construction point, I mean, if that is a possible solution to the problem, then it doesn't matter if it was left untouched. Everybody realized it should have been changed to give effect to the closure notice.
But there is no basis of construction that would mean that they had amended something that it is acknowledged they did not amend. The mistake is that they did not amend it, and that's clear.
Yes.
Is it necessarily as clear as that? I mean, looking at paragraph 191 of the Upper Tribunal, they say it was found to be inconceivable that a reasonable recipient would have thought that the amendments restricted the closure notices in the way claimed. The recipient would have concluded that there was a simple secretarial error. So this is very much in the territory of ignoring obvious mistakes that one finds in other areas of the law. It's a sort of John Prescott principle. What's said may not make grammatical sense, but everyone knows what it means, and therefore that's how it is to be understood. Why shouldn't that apply, so that even though looking at the documents there's no amendment to box 121, well, actually everybody knows that's what's meant?
Because the amendment, like the closure of the inquiry, is an administrative act by HMRC. The fact is that they did not amend that box, and no amount of construction would change that. It's not a question of trying to work out what they ought to have done or what they had intended to do. What in fact did they do? What they in fact did was amend, one would think deliberately at the time, amend the figure in box 107 and leave untouched the figure in box 121. Now, the reason that I say really the question in this issue turns on the scope of the tribunal's power, which is how the Upper Tribunal to some extent viewed it, and also the FTT.
Just before you get on to the actual law, can we see what the revenue did do in relation to this return?
Do you mean the closure notice itself? I don't know that we have that in the bundle. Just see if the FTT made specific findings about it. Ah, yes, that's right, yes. My learned friend has just noted that it probably will be as part of the appeal documentation in the core bundle.
So that would be, tab 29 in the core bundle.
So, yes.
So 629 is the relevant year.
627 is the closure notice, the notice of completion of inquiry in relation to Gunfleet Sands for the period that we were looking at in relation to that return. And at the bottom of that notice, it states amended as per communication from Graham Seawright of the 3rd of August 2017. That links to a letter that was sent by a Mr. Seawright, which is referred to in the FTT's findings at 226. And that closure notice then sets out the amendments to the computation.
Which page are you on?
It's page 627 of the core.
Do we actually see the word closure notice anywhere, or is that just really just the shorthand for notice of completion of inquiry into a company tax return in the top right-hand corner?
I think that's just the shorthand for that formulation of words.
Yes, everyone calls it a closure notice, but it's not it's not the language one finds on the form itself.
And we don't have the communication from Mr. Seawright.
I don't think we have the communication from Mr. Seawright.
Sorry, I can't find that reference to Seawright.
And that's towards the bottom of 629.
Oh, 629. Oh, yes.
So I'm told that we do have Mr. Seawright's letter. Page 621.
So where do we find what's suggested to happen to the boxes?
So that is what is done in the notice of completion of the inquiry.
So we're back at 629.
Back at 629. Mr. Seawright's letter sets out what the revenues case was in principle as to why it was drawing the line where it drew it. That case I don't think really is
Yeah, I see.
now advanced. Then 629 is the notice of completion of inquiry for that period.
And your point is we still see there the qualifying expenditure at 134 million.
Yes, that figure is untouched. What is amended is the writing down allowances.
Do we see that anywhere?
Yeah,
or is that just something
you
one
have to do a comparison exercise in order to find that.
So your central point is that the 134 million figure has been left unchanged.
That's right. If you, what you can do is compare the figures of expenditure and allowances that are claimed with the figures that are set out in this document. And what you can see when you do that is that there was no amendment made to the amount of qualifying expenditure that's claimed. But the allowance claim is reduced. These figures, are, as I say, are recorded in 93 of the FTT's decision.
Yeah.
Where before the FTT, we did do that exercise of looking at the different closure notices and seeing what adjustments were made. As a result, the FTT makes the findings at 93 about the adjustments that were made to the returns following the closure notices.
Yeah.
So they're set out with the figures at 93, internal page 17.
Your complaint was that the amount of qualifying expenditure which was removed by the revenue was removed from the wrong box.
That's not the complaint. At the moment, it's just an observation.
Sorry, that's your point at the moment.
The point is that so you have a pool of qualifying expenditure, and then what happens is effectively that's amortised and allowances are given in respect of that, so that there is then what's called a writing down allowance.
I understand that, yeah.
Yes.
Yeah.
And so what the revenue did was amend the amount of the writing down allowance that is used to compute the amount of taxable profit for that period, but they did not amend the pool of qualifying expenditure, which is carried forward from period to period.
Yes, but in amending the writing down allowance, they amended it by too much. They reduced it by too much on your case, didn't they? Because they used the figure that should have been deducted from the qualifying expenditure.
I think that is correct, my lord.
I was just looking...
In terms of the quantum.
So looking at page 549, which is, I'm afraid, a different company, but it's the one I was looking at. The complaint is made in relation to... I think 549 is Gunfleet, so isn't it? Paragraph 41. There's a point made at the latter half of it. HMRC's amendments should not, therefore, in any event exceed the capital allowances claimed. Just read the end of the paragraph. Isn't that making the point that too much was deducted because it was deducted from the wrong box? Or the wrong amount was deducted from that box?
So the short answer is yes, that is right, although that is a different error in the sense that they reduced the writing down allowances by too much.
So how does this work? If you're reducing the writing down allowance, logically that must mean you're implying a reduction in the pool, mustn't it?
Well, the way it ought to have worked is that they would amend the amount in the pool and consequently would amend the amount in the writing down allowance.
And if you are changing the writing down allowance, as you're purporting to do, does that not imply that you think that the pool is smaller?
Well, it certainly implies that you think it ought to be smaller.
Yeah.
But the fact of the matter remains that they did not amend it.
So I think the point is put slightly more clearly at page 576, what I was trying to make. This is based on the Walney Offshore Windfarms Ltd return. So paragraph 40, amendments of 15 million odd were made by a reduction of the allowances claimed. I understand the point being made here that that was the adjustment that should have been made to the qualifying expenditure. under in 41, what's being said is the amount that should have been deducted from the written writing down allowance was only 3 million, i.e. 19.34%. So what's being said is you deducted 15 million, which should have been deducted from the qualifying expenditure pool from the writing down allowance. If that's correct, it follows as night follows day that correcting the error that you are complaining about should have also resulted in a correction to the qualifying expenditure pool.
Why does it follow as night follows day, my lord?
Well, because what you're saying, the complaint being made here in your grounds of appeal is you've taken the right number, 15 million, but deducted it from the wrong box. You should have only deducted 3 million from this box, and the 15 million should have been deducted from the other box.
Yeah, so there should have been 2 amendments made.
Yeah.
There was only one, and the one amendment that they did make was wrong in terms of quantum.
Yes.
But the fact remains that they did not amend the first box. And the question in my submission is whether there is a power to correct that oversight.
My point is that within your detailed grounds of appeal, you're pointing out the error that this should have been deducted from the other box.
But there's no dispute that was the error. The question is what can then be done about that?
I think it probably goes to what's within the parameters of the appeal.
Well, that really gets to the heart of the question about Section 50, because there's a question as to what's within the scope of the appeal, but there is a separate question as to what powers the tribunal has within that appeal. Now, for the tribunal to be able to amend a part of the return that the revenue did not themselves amend, there would have to be a power within the statute to allow them to do that. The tribunal, of course, is a creature of statute. Its powers are statutory, and the extent of those powers is a question of the proper construction of the statute which confers them. And an exercise outside the scope of those powers would be an error of law, however fair or however obvious it might seem.
One thing I hadn't quite appreciated until we were just looking at these documents was the revenue never say, we are changing the figure in box such and such. We are leaving unchanged the figure in box whatever it is. You get a letter and calculations from which you infer that supposition. But they've never committed themselves to saying, we are leaving untouched the figure in box whatever.
Well, it's more, with respect, it's slightly more than an inference because it is just a numerical difference. So, yes, I mean, one is not guessing as to what the amendment is, it is arithmetically apparent. So it's not a question of trying to infer what the amendment might be. You can see what the amendment is.
Yeah.
So as I say, it's not a construction exercise in that sense. There is no doubt that they amended what was determined as the writing down allowance. I mean, they've never tried to contend that they amended anything else. Their case essentially is that, well, it must be the case that the tribunal can do something about this error. Now, just one more point of background, if I may. The companies had argued below, and you've now seen Mr. Seawright's letter, not necessarily in detail, but the position that was set out there is one of principle. It was about where to draw the line in the development process, and costs incurred before that line is drawn don't qualify, and costs incurred after that line is drawn do qualify. That was their essential position. There hadn't been any dispute in terms of quantum of amounts. It was always an argument based in principle, and it was on that basis that the companies had argued before the FTT that really this was a question of principle, and it wasn't open to the revenue to start taking issues of quantum. That was the point that was argued before the FTT, or one of them. And that is what engaged the question of what's in the scope of the appeal. And the FTT decided that issues of quantum were within the scope of the appeal, and that conclusion wasn't challenged. Now, your lordships are no doubt familiar with the basic mechanism of the return and the consequent inquiry by HMRC, and then the closure notice position. The closure notice requirements are set out in paragraph 34 of Schedule 18 of the Finance Act 1998. That's in the authorities bundle of sections at page 60. And what the closure notice has to do is state whether any amendments needed.
Sorry, where are you reading
There's
from?
para 34. Now, I think there are two versions of 34 in play over the relevant periods.
Yeah.
It might be usefully take the most recent one, which is in page 61. Do your lordships see in the footnote prospective amendments, which takes effect from 1st of April 2010? This is the version that's cited in the Upper Tribunal. Nothing turns on these differences.
Yep.
That the closure notice must state that in the officer's opinion no amendment is required of the return that was the subject of the inquiry, or make the amendments of that return that are required to give effect to the conclusions stated in the notice. And in the case of a return for the wrong period, to make it a return appropriate to the designated period. And then an appeal can be brought. This is now subparagraph 3 of 34, which you can see at the bottom of 60. An appeal may be brought against any such amendment of a company's return. So that's what the appeal is against. Now, the Taxes Management Act is actually geared towards assessments and largely personal matters rather than corporation tax matters. But Part 5 of the TMA is engaged for the purposes of appeals and so on in relation to company tax returns. Now, if your lordships would turn to page 34, this is within Part 5 of the TMA. Section 48, subsection 2, provides that in the case of an appeal other than appeal against an assessment, the following provisions of this part of this Act shall, in their application to the appeal, have effect subject to any necessary modifications. And the reason for that is that in the sections that follow, the references are to appeals against assessments. And if your lordships turn to page 37 at the bottom, you should see section 50. And section 50 sets out the power on the part of the tribunal to increase or reduce an assessment where it is decided at the conclusion of the appeal that the appellant has been overcharged or undercharged. So section 50 by default is dealing with appeals against assessments, what 48 does is allow that section to be read in a way which allows you to have the same power in relation to appeals against things other than assessments. And in this case, it's an appeal against an amendment. Now, as your lordships are aware, of course, the jurisdiction of the tribunal is fixed and is defined by the terms of a closure notice. That's now well established in the jurisprudence. What I did just want to show you is a statement by the Court of Appeal in Investec, which is in the Authorities Bundle at tab 23, page 401. Now, the facts are somewhat complicated. You had two appellant companies that became partners in a number of leasing partnerships. They incurred costs in acquiring their interest in the partnerships, and they later made capital contributions to the partnerships. And the partnerships then sold off their assets, generating profits in their hands, much of which was paid to the appellant companies. And the revenue took issue with the appellant companies' tax returns and concluded that where they had reported losses, the losses had been overstated, and where they'd reported profits, the profits had been understated, and one can see that at paragraphs 14 to 16 in the decision. That the losses and the profits that the companies had returned were based on the claim that the expenditure was deductible against their trading profits. Now, the revenues closure notices were accompanied by letters, covering letters, that set out alternative arguments that they said they would like to deploy in particular scenarios. And they are summarised at paragraph 19 at 409. But the key point is that the consequence of those alternative arguments in terms of the assessments would be to bring more into charge as profit. So the revenue had made amendments in their closure notices as to the amount of taxable profit or loss, and the effect of the alternative arguments would be to alter the amount of that profit or loss in a different way. So it was a different quantum. So in terms of the return, it's the same entry that would be adjusted. What would be different about that is the quantum of the adjustment. Now, the taxpayer challenged whether it was open to HMRC to do that, and consideration of that issue begins at paragraph 25. And as Lady Justice Rose notes, just at letter J, it is established that the revenue can put forward alternative arguments to support an adjustment in a closure notice. The issue at stake was whether HMRC could put forward alternative adjustments to the figures, one which is in the closure notice and one which is in related correspondence. But as I've sought to explain, it's important to be clear that it is not that there would be an adjustment to a different part of the return. And then as to the court's decision on the point, the key parts of the reasoning in my submission are set out in paragraphs 70 to 73, starting at page 424. If your lordships would mind reading 70 to 73, please.
Yeah, I'll do that.
I'm grateful, my lords. Now, there's a very clear statement between F and G that the focus is, in this context, must be on the amendment. The amendment is the matter in question, which then restricts the ambit of the appeal, at the conclusion of which the tribunal may decide that there's been an overcharge or an undercharge, and so make a reduction or increase. Now, the Upper Tribunal disagreed with quite how one should read those sections, and said in its decision that the statement that I've just referred to in paragraph 70 must be qualified by what comes later. Of course, I accept that you don't read a judgment like a statute, you have to read it as a whole, but it is very clear that Lady Justice Rose considered that the amendment in question was at the very least of very material importance. But it is absolutely clear that any purported exercise of the FTT of a broader power than that which is conferred by the statute would be an error of law. My submission is that, really, regardless of the scope of the appeal, the key question is whether the tribunal has a power to do what HMRC failed to do, and specifically to amend a part of the return that HMRC did not amend. And as I've sought to emphasise, Investec was not such a case. the change that was sought by HMRC and Investec was a change to the quantum of the amendment. If one imagines the amendment as a dial, it was to turn the dial to get a higher or lower figure depending on what argument was being run. In this case, what HMRC need to do is identify a power on the part of the tribunal to go back and make a different amendment in the sense of amending a different part of the return. They have to find a power that enables the tribunal to go back and amend box 121 instead of box 107.
And just relating this back to the statute, as you pointed out to us, the closure notice must, it says, make the amendments of that return that are required. So where a closure notice says I am amending, let's make it by reference to boxes, the figure in box X to Y, it's nevertheless open to the revenue to say, well, Y is wrong, it should be some higher figure.
That's right. That the amendment that I've made, which is a quantum point, should be a higher or lower figure depending on this particular argument. And it is also open to the tribunal, under section 50 read with section 48, to adjust the quantum of that amendment.
So at least to that extent, you can depart from the amendment put forward in the closure notice.
That's right.
And why should it be different if the logic suggests that there should be some other adjustment?
Because the only power that has been suggested as being relevant to this question is the power conferred in section 50. And the power conferred in section 50 allows the tribunal to increase or reduce the amount of the assessment, or, read with section 48, the amount of the amendment. They can increase or reduce the amendment. What they cannot do, under the terms of section 50, is amend something else.
Might it not be said that if the appeal relates to an amendment to box X, that the answer to that as a matter of law leads to a consequential amendment to box Y, that falls within the scope of the appeal?
The issue may fall within the scope of the appeal, but the question is what entitles the tribunal to amend the other part of the return?
Well, the tribunal has to decide the appeal on the law and the arguments presented to it, including any arguments it might wish to adduce of its own motion, subject to well-known safeguards. And in the end, it decides what the law is and what the result should be. And as my lord says, it would be an extraordinary result, would it not, if nevertheless the amendments can be made to give effect to the conclusion which the tribunal has reached and considers to be correct, and not only as between the parties, but also bearing in mind the interests of the general body of taxpayers as well, if that couldn't be given effect with by making changes not only to the box which started off the whole process, but also to any knock-on consequences.
That might well be considered undesirable, but the question is whether the statute confers the power to do it. Now, part of the problem of this, or in fact probably the source of the problem, is that the TMA, as your lordships well know, has been amended and amended and amended over the course of half a century or more. And what started as being something that was simple, where the revenue would assess, and then the question is whether that number is right or wrong, that machinery has been used to deal with other administrative matters that the revenue can introduce, such as amending self-assessments or amending returns that the taxpayer puts in, which means that the power as originally conferred may no longer do exactly what is necessary to do in order to give effect to a conclusion on an appeal. But the answer to that is not to try and legislate by construction to spell out a power in section 50 that enables them to do it. The simple question is whether section 50 does enable them to do it. Now, the Upper Tribunal said, well, it would be very odd if that were the case, that the tribunal were not able to give full effect to its decision. With respect, why is that so? The role and the responsibility of HMRC includes carrying out inquiries into tax returns and making amendments as they see fit. The role of the tribunal is to adjudicate over disputes in relation to what HMRC has done. Why does it follow that the role of the tribunal is to go back and redo HMRC's job or correct errors or mistakes that they have made in the course of that? In my submission, it's not odd that the revenue should be left to sit with their own errors in that regard.
I mean, one reason your submission has less attraction than it might otherwise have is because we can see the mistake that was made at the outset. So suppose a different sort of case where the revenue made absolutely no mistake, they adjusted a particular box, then there's an appeal about that, then you say, well, it couldn't be right for the tribunal to say there should be some completely different amendment to some completely different box. And I see force in that, but then one sort of comes back to the starting point, which is what detracts from the attractiveness of the submission, which is, well, really, it was obvious what the revenue meant from the start.
I take entirely my Lord's point, but the question is that the scope of the powers of the tribunal do not depend on whether the taxpayer thought that the revenue had made a mistake at the time, whether you had a sophisticated or an unsophisticated taxpayer. The powers of the tribunal are set in the statute. And the question is, regardless of what the court might think of the relative fairness or merits of the particular point in this particular context, does Section 50 confer upon the tribunal a power to amend that which HMRC did not amend?
But is there a separate question, which is, well, when you look at the closure notice, whatever you can see in terms of a particular figure in a particular place, actually the nature of the amendment that was being proposed necessarily involved an adjustment to the pool as well as to the writing down allowance.
Except as a submitted, that is simply not the amendment that was made. And it is not, as a submitted, a question of inferring. There is an arithmetical difference which tells you what the amendment is and what the amendment is not. And it's always been accepted by HMRC all the way up that they did not amend the figure of qualifying expenditure in the pool.
Yeah.
The debate has been around whether there is a power to do anything about that. Now, the reason that I submit that the proper construction of Section 50 is at the heart of this issue is how it links into paragraph 88, which I haven't yet shown you, Lordships. As I said to the Upper Tribunal, it is accepted that if Section 50 confers a power to amend the pool of qualifying expenditure, then that pool can't be taken to be conclusively determined for the purposes of the paragraph that I'm about to show the court. But if Section 50 does not confer that power, such that the amount cannot be changed now, then in my submission on a proper, sensible construction of paragraph 88, that figure is to be taken as conclusively determined. If I could just briefly show you, Lordships, that paragraph. In the authorities bundle at page 62, it's tab 8. This is a provision found in part 11 of Schedule 18. And it provides that it applies to an amount stated in a company tax return for an accounting period, which is required to be included in the return and which affects or may affect A, the tax payable by the company making the return for another accounting period, or B, the liability of another company for any accounting period. And by subparagraph 2, if an amount can no longer be altered, if such an amount can no longer be altered, it is taken to be conclusively determined for the purposes of the Corporation Tax Act in relation to that other period or other company. and then subparagraphs 3 to 5 explain what is meant by the term can no longer be altered. And by subparagraph 3, an amount is regarded as one that can no longer be altered if A, the period specified in paragraph 15.4, which is the general period for amendment by the company, has ended, B, any inquiry into the return has been completed and the period specified in paragraph 34.1, period for amendment by the company after inquiry, has ended, C, if the Inland Revenue amend the return under paragraph 34.2, the period within which an appeal may be brought against that amendment has ended, and D, if an appeal is brought, the appeal has finally been determined. Now, in fact, much of the application of that paragraph is common ground. It's common ground that the amounts of qualifying expenditure were amounts stated in the return, and that they were amounts which were required to be included in the return. It's also common ground that they are amounts which affect or may affect tax payable by the company in a later period. So there's no dispute about the threshold conditions. The question is whether that amount can no longer be altered, which is the statutory phrase. And we can narrow the dispute down still further in relation to that, because it is agreed that the period specified in paragraph 15.4 has ended. It is agreed that any inquiry into the return has been completed, and the period specified in paragraph 34.1 has ended. Now, as regards C, the revenue have amended the return under paragraph 34.2, and the appeal within which an appeal may be brought has ended. The question is whether condition D is relevant. And the essential point that's made by HMRC is, well, you have had an amendment to the return, and you do have an appeal still on foot, and that is yet to be concluded, and therefore the amount of the pool expenditure cannot be taken to be no longer cannot be taken to be conclusively determined. Now, as I've said, if I'm wrong in my submission about section 50, then I accept that that amount is up for grabs. But if I'm right about the parameters of the power in section 50, then in that circumstance, in my submission, it makes no sense to say that the unamended amounts are still open to alteration, simply because an appeal against an amendment to a different part of the return is extant. On HMRC's construction, it's sufficient that there's any appeal on foot in relation to any amendment to any part of the return, even if that amendment and the associated appeal have nothing to do with the amount in question. Now, why in that circumstance would the fact of the appeal make all the difference? It is exactly the kind of literal construction that the revenue have been successfully resisting for the last 40-odd years. On a purposive construction of the paragraph, which takes account of the fact that the statutory phrase is can no longer be altered, one has to ask a realistic way, is the amount in question an amount that can be altered? So where subparagraph 3c is talking about an amendment, it must be understood as referring to an amendment which is relevant, i.e. an amendment to the amount in question. And where subparagraph 3d refers to an appeal, it means an appeal against such an amendment.
Could there be any scope for the law on rectification of documents to have a role to play in all this? I mean, if this were a contract, or indeed a unilateral document of some kind, outside the context of tax appeals, one could apply the ordinary law on rectification. This would be a pretty clear case to rectify an obvious error. I mean, in fact, probably it would be unopposed. And one might even, as I suggested earlier, be able just to construe one's way out of the problem. But even if that wouldn't work, at least rectification could provide an answer. And there certainly is authority that in some tax contexts, rectification can apply. For example, in what used to be called Section 54 agreements. I'm not quite sure what they are nowadays. But
There's still Section 54.
still, so that's one bit of the TMA which is relatively unscathed. So I once had a case about that many, many years ago.
There is, in answer to my lord's question, I think that is a line of argument that it would be for HMRC to
Yes,
take.
quite. And I'm not suggesting you should
I mean, it would
volunteer.
be a novel point.
Well, the answer is nobody has suggested that. Nobody has really, as far as I can see, has. But the merits of your case on this issue are such that one is looking around for a solution if one can decently find it.
Well,
You won't be surprised to hear me say, I don't think.
I understand why my lord says that.
Maybe
but,
this is a more
it's-
for Miss Wilson in due course.
But I mean, from the position of the appellants, HMRC made an error.
Yep.
Why should they accept that a part of their return which was not amended should be amended simply because the revenue have made an error and it's considered unfair that they should have to suffer that?
Yep.
The question is whether there is a power to make that change, and if there isn't a power, why should they accept that there is?
And of course, at your return as submitted, I mean, it was, in a sense, contained precisely what it was meant to contain, didn't it? I mean, no, sorry, I'm confusing myself now. It obviously didn't, in the sense of, but the figures for the pool expenditure were correct.
Well, there was no, as far as the appellants are concerned, there's no error on their part, and there's certainly no any sense of any wrongdoing. I mean, there are many instances where there are mistakes made by the taxpayer, and the revenue certainly don't just extend a hand of generosity to correct errors, even where they think it's unfair. The question is whether the statutory powers within which they have to operate allow them to do it, and the same is true of the tribunal. So it's not a question that turns on fairness or merits of that kind. It is simply a cold statutory interpretation.
Yes.
Can I understand the practical implication, both for the particular tax year and any subsequent year? So in the particular tax year, they're saying that they're reducing the writing down allowance, but you say not reducing the pool. Are they still allowed to reduce the writing down allowance on your case, or not?
Yes, within the years that are within the scope of the appeal, yes, because that is the amendment that has in fact been made, and that's within the scope of the appeal.
But in the next year, you say, well, we're entitled to full credit for the pool from the previous year, less the lesser amount now taken off by way of writing down allowance.
So in future periods which are outside the scope of the appeal, the operation of paragraph 88 means that the pool of qualifying expenditure is taken to be conclusively determined, and the writing down allowances will follow from that.
And so to the extent that the revenue might win on the writing down allowance point, it really doesn't help at all, because in the next
subsequent
year,
periods,
the pool is reduced by less than otherwise would be the case, and you start off with a larger pool.
And the allowances follow from that.
Yes, I follow.
But I mean, the purpose of paragraph 88 is to provide certainty for the parties involved, where you have an amount like a loss that you carry forward, or a pool of a qualifying expenditure that is carried forward, so that the taxpayer knows what it can put in its return.
Yeah.
So in my submission, it makes proper sense of the provision to read subparagraphs 3C and 3D as referring to amendments and appeals against amendments which affect the relevant amount. And that makes proper sense of the provision and the notion of an amount that can no longer be altered. And although the term can no longer be altered is itself a term which is effectively defined by subparagraph 3, it is accepted as a matter of statutory construction that one can have regard to the words that are being defined. And Parliament has chosen to use the term can no longer be altered. That conveys a strong indication of the kind of circumstance at which the condition is aimed. One is looking at a situation where the amount can be altered. And the various instances in subparagraph 3a to d reflect the various means by which an amount included in a return can actually be changed. So on that interpretation, on the facts of this case, one does not move beyond limb B of subparagraph 3 because HMRC did not amend the relevant amount. And that, in essence, is the appellant's submission on that grant. As I've said, if I'm wrong about the scope of Section 50, the amount can be altered, and then that, of course, affects the application of paragraph 88, but the two feed into each other. The tribunals below considered that there was a power in Section 50 to make the amendment. If I may just say something briefly about what the Upper Tribunal said in relation to that, which was that what one had to do was give the sections a purposive construction. This is at paragraph 235 to 237. And at 235, this is internal on page 43. The Upper Tribunal starts by referring to self-assessments. And the self-assessment figure, the bottom line tax payable, is the product of a computation using various items within the boxes in the return. That, of course, is true. But the Upper Tribunal says that it would be wholly artificial and impractical for us to conclude that the only part of the return which can be altered by the tribunal is that part which falls within the self-assessment calculation of the amount of tax payable for the relevant period. And then at 236, this is clearly a situation where it's a paradigm example of the need for a purposive construction of the legislation. Parliament must have intended the tribunal's powers in Section 50 to align with the scope of the appeal. Otherwise, there'd be a lacuna. And at 237, the solution that's proposed is to start from the premise of an appeal against a self-assessment. That's starting at line 4 in paragraph 237. In the case of a self-assessment, the tribunal can amend parts of the return to give effect to its view the self-assessment undercharged, provided those parts of the return are within the scope of the appeal under principles discussed above. As applied to appeals against amendments, similarly, the concern is not necessarily restricted to adjusting the given amendment up or down, but can extend to those parts of the return which are consequential to the subject matter of the closure notice conclusion. Importantly, the key part of the legislation providing the scope of the purpose of construction we consider is contained in section 48(2)(a). That section provides that where an appeal other than an appeal against an assessment, the TMA appeal provisions have effect subject to any necessary modifications. In this case, that means one does not simply substitute the word self-assessment with amendment. Instead, the statutory rules are modified to bring them into line with the position for appeals against self-assessments. In doing so, the venerable principle is given effect. The tribunal is given the power to make the consequential amendments required for the taxpayer to pay the right amount of tax. Now that, with respect to the Upper Tribunal, is based on a false premise, because in the context of appeals against self-assessments, the power to amend the self-assessment is not a power to amend all the bits of the return that feed into the self-assessment. And I, for myself, for what it is worth, I'm not aware of any case where that has been done. A self-assessment is a discrete part of the tax return. It is defined in paragraph 7 of Schedule 18, which is at page 49 of the Authorities Bundle, tab 6. And it's defined as an assessment, brackets, a self-assessment, of the amount of tax which is payable by the company for that period on the basis of the information contained in the return. So the self-assessment is a figure. The self-assessment is not a synonym for the return. So with respect to the Upper Tribunal, the premise of its construction is wrong. The Tribunal can't go back and just amend the return. What the Tribunal can do is increase or reduce the assessment, which is the self-assessment as defined in paragraph 7. They can't go and change boxes in the returns as if they were concluding an HMRC inquiry. So that construction of section 50 in my submission is wrong, and the source of the power has to be section 50, it's not section 58. And if that is right, and there is no such power, then it would be an odd construction of the notion of amounts that can no longer be altered in paragraph 88, which treats amounts, and indeed the whole return, as if they could be altered, when in reality they cannot be. Unless I can assist further, those are my submissions on ground 3.
No, I don't detect any questions. Thank you very much. Thank you very much, Mr. Jones. Ms. Wilson.
Thank you. So what I'd like to do is follow the order that my learned friend took. In relation to the qualifying expenditure issue, as we have done below in the 2 courts below, I will make submissions on the law, and my learned junior, Ms. Parry, will, I think probably fairly brief in light of the way my learned friends put it, but make the submissions on how the legal test, as we say the Upper Tribunal rightly put it, applies to the facts, and by giving some examples really, and just to explain how the practical implications and what it means for this case, and why no error of law, fundamentally. So, if I could begin with, I think what I'd like to do is begin by summarising what I say the Upper Tribunal actually decided the test was, and sort of summarise the reasoning by which they got there, and then make that good by taking the court to the authorities. The ones we say are relevant, and then the ones we say are irrelevant. So the starting point is, of course, what's the meaning of the statutory words, section 11.4, what's its scope? And the essence of it, what the Upper Tribunal decided, is that you begin with the actual supply for use of an actual item of plant. And that's really what they're saying at 179 and 181 of their decision. And you draw a line around that. And within that curve is the bare purchase price of the plant, or its component parts, you have to assemble it, and any parasitic expenditure, which is a helpful phrase which appears in Urenco in the Court of Appeal, such as transport and installation and similar, so things analogous to that. and those things, because without them, the provision is incomplete or inchoate. They make the plant usable, and a provision is a provision for use. That's what a provision is. And that comes from Benedetto, fundamentally, and Barclaycombe. And these, as I say, these items are within the curve because a provision is an act. I think that's what the Upper Tribunal saw very clearly. It's a supply for use. And the word on the provision of, takes a narrow meaning. Maybe back in 1940 it could have been developed into a very broad meaning, but the cases have chosen, the House of Lords have chosen to give it a narrow meaning. And the question is whether the effect of the expenditure is our provision, the supply for use for the purposes of the trade. And so it's not, and Barclaycombe, Benedetto, Samarkand, the Court of Appeal, they all very strongly either indicate or say that. And so it's not enough that the expenditure is in connection with the provision of plant, or incurred with a view to, or even directly related to, because that could mean absolutely anything. It's one of the glosses on the glass. And what I say is when the authorities use phrases like directly related to, or it appears in the manuals when the manuals cite J.D. Wetherspoon, what they are just glosses, and they don't have any, they're not creating a separate, setting up some new test. They're simply, usually they are describing the very facts in front of the particular court that used the phrase. And so in the end you come back to what the House of Lords was saying in Barclaycombe, Benedetto. And that is, in a nutshell, is what the Upper Tribunal decided, the positive meaning, if you like, of the test. And because of this, as I said, the paradigm example of expenditure that's within Section 11 is the bare purchase price, and that all the cases say that. And so to make it more practical, so it's a hardware store. It's what you pay for the supply, for the thing to be handed over to you. And if you're buying from a catalogue, it's the price you're required to pay, plus presumably delivery, transport. And that's true whether it's in stock, or it's not in stock and it's made to order just for you, because you're the only person that's asked for that. Or it's partially, might be to a very small extent bespoke, or actually fully bespoke in the sense that you make this item, but you give me the option of specifying particular dimensions or colour or something, and so I'll tell you what I want. That might up the price, so you end up paying more. All of that is allowable, what you pay. That's what you pay for the provision of the item on the basis of the meaning given to the words by the cases. As I say, I'll make that good when I go through the cases. And then, of course, if the plant has to be assembled, because you're buying component pieces, or fabricated on site, it's the cost of the component parts, but also the labour cost. And if you need a very skilled labourer, then it's all of the cost that they charge with all of the expertise and judgment that they're bringing with them to do the job. That's just part of the ordinary meaning of provision for use, what you're incurring on. What you get in return is the provision of that plant for use, because the labourers have come in and they've installed it. So just to pick up, I think I went back and reread our skeleton, because I didn't agree with quite the way my learned friend was putting our case, or what the tribunal decided. This intellectual versus physical distinction isn't one that I recognise as being our case, or that the Upper Tribunal were really making. That the distinction is between... The trouble is, the word provision is actually the best use to the best word to use to describe what's going on. But because the provision of a physical item is fundamentally a physical provision, the supply for use, and they're identifying that activity, if you like. And then they're drawing a distinction between planning and gathering data and information, which they call the intellectual processing. But so the revenue are not saying, the Crown's case is not that if you need to assemble a piece of plant and you buy the component pieces, that you're not allowed to pay the cost of the labourer because he's intellectually, or she is intellectually, making judgments about how to install. That's nowhere in our case, or in my view, or my submission, the Upper Tribunal's decision.
Can I just check on the tangent that I was briefly going off earlier this morning? So suppose what you're buying is not something you can just get over the counter in the hardware centre, but something that has to be made for you. And in respect of that, you have to enter into a bespoke contract in respect of which you incur legal fees. Are those qualifying?
Well, it may be, and maybe I should just check, but I think they'd be regarded as the part of the overheads, or I suppose the cost of acquiring. I mean, if you need a contract to acquire the thing and the rights, then they would be sort of subsumed into the actual acquisition of it.
And there's no principle that the taxpayer has to get the best bargain available or spend the least amount of money or that somehow considerations of that kind cap what is allowable, provided it is expenditure on the provision of the plant.
Absolutely, and that's in fact one of the points made, in fact, by your lordship in Samarkand in the Court of Appeal, that there's no test of was it well spent, which ties into the abortive expenditure point. The film rights in Samarkand turned out to be worthless. They spent 8 million. They weren't worth anything. Presumably, something sufficiently in existence was bought that everybody thought they had a master negative. I don't know. It's a very artificial film scheme which failed on every single count. But yes, it doesn't have to be well spent. And if you buy the most expensive cooker for your restaurants, well beyond anything with the capacity that's needed, on the face of it, you then use it for the purpose of your trade. It's allowable, and vice versa. Which is one of the problems with the first tier test, which is why nobody's supporting a necessary design. You get the cost of what you buy.
Can I just ask this? If the taxpayers here had subcontracted installation to a third party, and to install the turbines, it was necessary for that subcontractor to undertake all sorts of studies, the same studies that were carried out here, but say, for example, to ensure there were no bonds underneath the surface they were drilling into. And they just added the cost of those to the price charged to the taxpayer. Would that have been expenditure on the provision of the plant?
I think I might just have to... Maybe we could come back to you on that, just because of the kind of the different ways you could treat those facts. But after lunch, I think...
Let's just take a very simple version of that, which is they do a survey on the seabed to see whether there are any water cooled.
I mean, and I think the simple sort of answer would be that, so installation is, jumping ahead a little bit, I think installation, the key point about that is it's obviously not a statutory relief for the costs of installation. The word doesn't appear. Installation, whatever it means in practice, it is, the costs are allowable if what you're doing provides you with the plant. So it's the part of the provision for use. So on the face of it, the installer comes with all of their skills and expertise and assesses the site. The actual, if you like, the installation started, if that's what the process involves, then the cost would be allowable. But I mean, as to the reality of the more extreme example, I just check what the answer is. So what I just finished sort of completing the test is laid down by the Upper Tribunal. As I say, I just wanted to clarify that this intellectual versus physical distinction isn't one that should be sort of, it's not accurately described in my submission, by the way my learned friend put it. And to the extent our skeleton might have suggested otherwise, I read it, I don't think we did, but just in case, that make our case clear.
I suspect there are bits of the Upper Tribunal which rather suggest that.
Yes, and I think that, but what I'd say on that is if you read their decision as a whole, I think what they and how they apply it to the facts, you can see that they're drawing a distinction. And as far as they were accepting the revenues case, which they do appear to have done, then certainly that was the revenues case that was the distinction. So yes, so the point about the assembly, the transport, the fabrication, or even the construction of something you have to make from scratch, they're all allowable because they're all of the same nature. They are the activity that provide you that item for use. And it is very much then at that end stage. It's the provisional supply for use.
And taking you out of your order for a moment longer, so as you say, it can encompass something that is made for you. Suppose you know you need a thing, but you need someone to turn your idea into a specific reality. So you get someone to design it for you, so that it can be manufactured. Costs of design?
Well, I think on the basis of the Upper Tribunal's test, no, because that's part of the.
And on the revenues case?
Well, the same. If what you're doing is having it made for you, you say, I want this, and then somebody makes it for you, then it's the cost they charge. And that's really just buying made to order or bespoke from the manufacturer. If you go to slightly different, in which the facts of this case, you're saying, or close to the facts of this case, you say, can you give me some advice and ideas about how I might, if I want to create this new business of a restaurant, can you tell me everything about the local market, the competition, the site, the best premises? What kind of furniture should I, or tables? Then that clearly on the wrong side of the line, because what you're doing is getting advice that would, and including all that would be, and actually they'll say, look, you could buy all this kind of furniture or whatever for your restaurant because it would be high end and you would end up optimizing your profit.
So let me take it. Say I want a website, and I go to somebody who can make.
I think that's slightly more complicated because it would be intellectual.
Well,
there is an intangibles relief. So there are other reliefs, of course.
Yes,
and
that's
what you're
true.
doing
I'm just
is
trying to say I want. I don't know what. I have to imagine that there's something that could be a physical thing that would be appropriate, and you go to someone who makes those sorts of things. And they say, look, we can do that for you, and we'll charge you £1,000 to design it and £10,000 to make it. The £10,000 is qualifying, the £1,000 isn't?
The design costs will not, in the sense that it doesn't get you the plant. What you ask, the first stage says, helps you decide what you want. The actual item of plant that you want. And you might not like the design. Or you might like the design but say it's too expensive, can you do a cheaper version? You will end up with something that you want, and then you put the order in, and then they make it for you, and the cost of the making is allowable.
So it's only when you, so to speak, have specifications
Well, or convert the drawings or the specifications and measurements into the plant. Before that, you really are just deciding what you want. What do I want to buy by way of plant? Do I need any plant at all? If I do, what do I want by way of plant? Should it be this big or that big, made out of this or that?
Yeah, so that in your answer, you've assumed the design is for the purpose of deciding whether to buy a particular type of plant. But what if you know what you want? Whatever you want requires some pretty precise design to cater for birds in the area, the seabed. So you know what you want, but someone's always going to have to design that. They go away and design it and then build it and charge you the combined cost of design and build.
But in a sense, that's just the same example. That having somebody design the thing is not the same as having somebody make it for you. In the end, there's always a decision to be made in any business. They will come to you and they'll say, here, this is what we propose. This is what we would advise that you have made, that you use in your business. And a decision has to be made yes or no. And that is conceptually different. And that's really the distinction that Upper Tribunal are making, is the first is the conceiving of the thing. And then the second is making it. So it's converting the drawing or the measurements or just the instructions. I'd like item number 1 in the catalogue, please. Converting it into the supply of the item.
So to take you entirely out of your course into a territory that I'm sure you'll be coming to later, I know it's a different relief. Buildings. Really, architects' drawings can never be deductible.
So so my instructions on this are that in 2018, none of this is before the court. In 2018, I think the new Structures and Buildings Allowances was introduced, which was the culmination of a whole history of various different sorts of building allowances, all providing generously or not for various different activities. And the current representation of that is in the Structures and Buildings Allowances. And it has its own code. Now, actually, my understanding is the wording does say incurred expenditure on the acquisition of a building. But then it is within a different...
Does it not say on the construction?
The construction of a building, I'm sorry. Yes, sorry, construction of a building. And then there's an express exclusion for costs relating to planning. But the construction of the building and the building allowances have really just taken their own course over the years. And it is, looking at the revenue manuals, it is the revenue policy to allow in relation to the costs incurred on the construction of a building a wider range of expenditure, which would include the architect's fees.
Is that
Yes. So,
I mean,
but
maybe
in the end,
it's
that
a
is
real
just the
world
revenue
answer, but it doesn't sound a
policy.
very intellectually satisfactory answer.
But it's just a different regime, which, in respect of which which has arisen over the years in its own, with its own history.
But the wording on the construction of a building sounds of anything narrower than the wording on the provision of plant. And yet, architects' fees can be taken into account. And even though you're explaining in the context of plant, it's only when you know what you want, you've got the specifications, that the expenditure starts to be relevant. Design costs aren't.
But it's, in the end, they are different words, and the words can, as a matter of either the policy or case law, take on their own meaning. And so, in my submission, it is dangerous to take from the words of a different section, which are, in the end, not before the court, and we haven't got any practical details of it, which are, as a matter of fact, given a particular meaning by the revenue, in part because of the history of the provision, and really take anything from it. So I think, in the end, we just come back to on the provision of, the statutory words in light of the case law.
Yes.
I think I'd be saying something similar about the relief for acquiring a master negative in Samarkand. I think the first two decision is also really not very relevant for the night reason.
Yeah.
So I had said that the paradigm example was the bare purchase price, and in the end, I suppose what I'm saying is it's almost by analogy to that you increase what's allowable incrementally with great care, given that that is the paradigm example of what is within section 11.4. And then more particularly I wanted to say that and actually I understand it's common ground now, I think, that there's no conceptual problem with starting with the actual item of plant, the successfully provided plant, because the intended object of the expenditure must be realised for section 11, and that was made clear by the legislative changes. And so if the trader's defrauded or makes a mistake about what he's buying, so what he's got isn't actually plant, it's intellectual property, or he's defrauded and he doesn't get it at all, no allowances, however well intended the expenditure. And here there was an issue about the identity of the plant. The first tip, and the only point I want to make about this is, in a sense, how irrelevant it is to the arguments we're having today. So nothing was lost, in a sense, by either side by the decision on that issue. And fundamentally, it's because the first tier was just, as the Upper Tribunal recognised, being asked to aggregate up or down items that were clearly independently, vast and capable of an independent operation. And when you have this sort of situation where you're really just saying, well, is the item of plant, the 12 turbines with cabling that are attached together by the array cables leading to a substation, is that one item of plant, or 12, or that with the cabling 24, whatever it is? In a sense, it doesn't really matter. Certainly it doesn't make any difference for the analysis in this case, because at the end of the day, when you're asking, was an expenditure incurred on the provision of the plant? I mean, I was thinking this, listening to the submissions yesterday, is in the end, everybody's been talking about the turbines or the cabling, but it doesn't matter if you call that part of the plant. More technically, we should be saying, each time we mention a turbine, this is only a component of the plant, because the plant's been held to be the generation asset. But as I say, I just wanted to make clear it doesn't really go anywhere. And the Revenue didn't appeal the Upper Tribunal's decision because, in part, it just said, well, it could have gone either way, and there was no error of law by the first tier. And of course, in the end, it doesn't matter. So that's where we stand on that. And one other point on this is that my learned friend sometimes talks about the wind farm, and I understood him to mean the generation assets. But just in case of confusion of terminology, obviously, in some senses, the wind farm is everything. Substations, onshore and offshore, all the sites, and so on, the thing as a whole. And this case is obviously about the generation assets, that's what I mean by plant.
And sorry, just to clarify the point I was getting confused about yesterday, it is common ground, is it? We are dealing here with what is now agreed to be one single item of plant, namely the generational assets, plural. I mean, the totality of generation assets.
Yes, so if there are 10 turbines,
linking cables.
If there are 10 turbines linked with array cables to the substation,
yes,
and that happens 6 times, there would be 6 items of plant. Because, is it all single one generation? I mean, it's the trouble is because they're called generation assets, but I don't think it matters. If I'm wrong, if the single item of plant is split up with a substation in the middle of it, then fair enough.
The stick I think I got the wrong end of. I thought what the Upper Tribunal was saying was that each individual turbine, by which I mean the structure we were shown the plans of yesterday, including obviously the foundations and the relevant cabling. I got it into my head that each of those was to be regarded as a separate asset, whereas Mr. Jones was correct in saying no, the agreement was, if I understood it, all the array of cables.
I think the only point I might be confusing everybody on is whether a single generation asset is, say, 10 turbines connected with array cables. But you could have more than one of those in any one wind farm. Is that right? Well, it rather goes to the point of why it didn't really matter.
Yeah, well, it's really a bit of a red herring, but it's conceptually important to identify the plant, because if you've done that, you know.
What do you... Yes, but so 150, the generation assets are the single item, but that didn't include the substations. I suppose that's the only point.
Generation assets is defined in paragraph 5 in a way that is consistent with your case, I think. So wind turbines and the array of cables which connect them to the offshore substation. That's generation assets. And if we then look at the diagram at page 324, one can see, as you say, that there are various different cables coming into a substation, so that I can see how you can say, well, actually, you get quite a few sets of generation assets within any one
That's
field.
how I had understood the
But as you say, I'm not sure it matters at all, does it?
No.
Or does it?
Well, I think it depends on the question that's being asked. But I mean, certainly my understanding was, if one looks at 145, the judge says, I have no hesitation in deciding that each wind farm is a single item of plant.
But one confusion of the first tier is he did think the wind farm as a whole could be a single entity, and nobody agreed with that. So I thought that where we came down to was that the generation assets were the plant, and it's the turbines connected with array cables.
Yeah.
That's a generation asset. It generates, together they generate energy, and they're connected to a substation. But it's the turbines and the array cables that are the plant. Perhaps everybody could reread it over lunch, but that was always my understanding of what we were arguing about.
Sorry.
So go on.
For my benefit, page 324, am I looking at one item of plant or on that page, or numerous?
Well, I would say maybe, so not the number of individual turbines. Everyone agrees that's not the case. But if you could follow through the array cables, you'd probably find they divide up into a number of groups of turbines, and each group would be could be generation assets.
So everybody agrees, do they, that the substation is not included?
Yes, it's not plant for the purpose of this appeal. There's been no discussion about it.
So the question is whether you take all the cables in the field, so to speak, in aggregate, or whether you have quite a few sets of generation assets within any one field. And it doesn't seem to make any difference at all.
In my submission, it doesn't, because in the end, you've got to ask. They certainly, each individual turbine did have to be installed in its own hole in the ground, and the cable had to be laid. And that's what we're talking about, and about the advice and information that led to decisions in relation to those sorts.
In terms of Mr. Jones' point about how the various surveys fed into the design of the overall wind farm, that point is as good or bad, however you define the generation assets relevantly, I think.
And actually that was...
Well, not now, but if...
Yeah. That in fact led on to the next point I wanted to make, which is just about terminology. And I just wanted to, because the word design is used in a number of ways, especially in my learned friend's skeleton argument. But first here, an Upper Tribunal called it a weasel word. And I I want to be clear what I say the Upper Tribunal were talking about when they talk about designing or the design process. And we find that in paragraph 162 of the decision, and 163, which is page 140 of the full bundle. And what they say is, in the context of design of plant or machinery, we consider the above contrast the two senses between the process of design and design as an end product made real in substance. The design process may be thought of as the process by which any number of decisions, including size, dimensions, material composition, component type, fabrication method, are made, so as to come up with a set of instructions which can then be used to make or construct the plant. So the process of design there, and obviously that could in itself be widened or narrowed depending on what they're doing, but because you could be designing, so the process of designing the layout of the turbines would include things like how close should they be together, in order that they are each able to do their job properly. And that's called wake, because they can interfere with how the wind, the wave conditions for a turbine behind it, depending on the wind conditions. So the process of design in relation to the layout there would, in the end, require you to look at the individual turbines and where they're placed. And that's what layout would be all about, or configuration, which is you need to know about the wind conditions, the setting, if you like, of the environment. But then equally, the process might want you to come up with a size, dimension, and composition of a piece of the foundations, so the cylinders, because the cylinder might need to be longer if the sea depth is whatever. But what they're distinguishing is that process of deciding, in the end, putting it very simply, what you want, or what you can afford, depending on the parameters of your business. But anyway, the process of design in this case is about providing the decision making, if you like. And then the studies, all these very, very complex and expensive studies, what they do is they arm the companies or the appellants with the information and data and with analysis that helps them make those decisions. So the design process is in very simple terms, really about deciding what to buy and where to put it, and whether you want it at all, depending on how far back in time you go in the development of this project.
I understood that submission to be they were distinguishing between deciding what you want or can afford. I didn't hear and what. What is distinguished with? So what's the other side of that?
Oh, well then having it made for you. So they took, their end point is coming up with a set of instructions. And that will have the specifications. So at that point, you've decided what you want. And then if you tell Siemens and they make it for you, there's a bit more to it than that. And Miss Parry will just make some submissions about the sort of nuances of that. But that's the basic position. And that's what the tribunal is meaning by the process of design. And of course, that fundamentally, that's their intellectual, conceptual process. So they're not, I think it's maybe paragraph 165, some of the judgment is a little philosophical. But I think if you look down to what they're actually doing in the judgment, that's what they're describing by the intellectual conceptual process. It's that process of making decisions and being informed in order to be able to make decisions. And then just one other point on designs, they also say, I think it's just at the end, I'm sorry, I've just lost it. I think it's, they also say, and I think it's one, so I've just lost the reference, but they also do say that you can talk about the drawings that are produced at the end of the process of design as being designs. But again, that's designs being used to mean drawings. And in the end, drawings are not plant. They're what will be used to assist you in having a provision of plant. I think that probably is in 162. And then at 163, they say the design costs in respect of which relief is sought are those arising in relation to this design process as described, and the data gathering to inform the design process. And that can be an iterative process. And when I come to McVeigh, it's clearly this is something very different to the designs that were being considered in McVeigh, which as a matter of hard fact and reality were tools of the trade. They were reference books used by the styling committee. And Mr. Justice Cross clearly knew and thought they were actually themselves plants, so all the costs ought to have been allowable. But when he goes on and does his further analysis, he is, as a matter of fact, talking about a case about books which are used as tools of the trade. And whether you call that plant or not, it remains the case that they're being used as tools of the trade. I mean, that's how they're being used. So that the analogy is, there's no analogy here because factually something very different is going on. Just two more bits of terminology that informs and feeds into in my submission that it sounds quite nice, but just because something informs or feeds into something else doesn't mean that the expenditure on on the information that ultimately fed into the actual provision of a plant is on the provision. Informs is used in a whole variety of senses, and sometimes it's about something really quite closely connected with the provision. Sometimes it's about something that's really very far away. And sometimes what is said to inform a decision on the design of an item of plant, in this case, is actually abortive expenditure. So the Ignatius Rock example in the page 324 of the supplementary bundle, work was done to find out that you couldn't use that particular area. So in a sense, that was abortive in the sense that that was somewhere you couldn't use. Or you could say, well, that meant you could avoid that and you could focus somewhere on this. But anyway, the point's a very simple one. And then on installation, I think I've probably made my point on this in answering the questions earlier. But phrases like how to install are also sort of ambiguous, could mean anything. And I think in this case, that in my submission, to understand what's meant is perhaps easiest to see actually what the Upper Tribunal decided. In other words, how they applied their test, and that's at particularly at paragraph 181 and 182. And what they are saying is that there's no special rule for installation or safe and effective installation. If you get your costs of installation, it's because they're completing the provisional supply of the asset. And so that determines the scope of what you're allowed. And so you look at what's actually done to install the actual plant. And that would include project management overheads properly apportioned to the actual installation. And in the end, it is a question of fact what's included in that actual installation. I was looking back at some of the evidence from below, and actually the first tier observed that the actual installation is very expensive. It's a very expensive part of the process. And all those costs will have been allowed. So this case is just about, if you like, the pre-development costs. The companies will have allowances for the actual costs, money paid to Siemens and so on, the actual installation and construction costs. And so I move on to the case law now, but I just sort of sum that up. We say that the tribunal has drawn a line, and you can say what that line is, which is you give the word provision the meaning of, the supply for use of the actual item, and you know what the item is. Everyone agrees that. And anything parasitic to that to enable the provision for use in the trade. And it's a relatively narrow in scope, and you don't go beyond it. And when there are difficulties in determining whether you've begun your construction or not, you go to the tribunal and you give the tribunal all the facts, and they say, well, actually, I think you're still in the decision-making phase, or that's part of the preparatory stage or the precursor to, or they say, no, actually, you'll get all that expenditure because on the facts in front of me with all the detail, that's part of the installation of the provision.
So it's inherent in this that it's important always to start with the actualizing of the plant.
Yes.
And then in a sense, and because you have to do that, one has the great benefit of being able to look backwards with hindsight and look at the whole process which led up to its eventual positioning and functioning in the trade.
Yes.
And that's looking at it from one end of the telescope. And at the other end, there's an element in play of remoteness, something which is too far removed from the end installation of the working, functioning plant. So be within the scope of the relief, and then that sort of very basic feeling is articulated in various ways by judges using expressions like remoteness, or what will also is a line and a circle. And
yes, I use
like
this
that.
as the curve or the
curve.
Yeah.
And these are all metaphors, but they perhaps help to give a feel for what it is we're groping towards.
Yes, and one thing I would say is that the nature of the test which has been articulated, or if you like, evidenced in the cases, Berkeley, Cullen, Benedetto especially, means that very clearly you can obviously have expenditure which is on the wrong thing. And so premises is a very easy example. So expenditure on the premises or setting, however specialised, however carefully it has to be designed and selected and chosen in order that your plant works optimally, is not allowable, because it's not on the plant, on the provision of the plant. It's on the provision of specialised settings and premises that enable your plant to work optimally. So that's a sort of an easy case, if you like, because physically you can...
Well, I'm not sure about easy.
Well, I make... Perhaps I should take that back. But in the sense that at least you can identify what the other thing is, because there's a well-established line of case law.
It's what Lord Hoffman called the premises test.
The premises test.
The Wimpy case, which is always my favourite case, because it expands the basic principles so clearly.
Yes, but fundamentally it's not because premises are special, it's because premises aren't plant, unless the premises are plant, as in the dry dock. So there is no special rule for money, there's no special rule for premises. The reason why you don't get relief for finance costs for buying an oil rig, or in the car wash cases where they want the construction costs of building this amazing, they had 79 of them, the Andorf is in the bundle actually. The company's going to build 79 car wash sites, amazingly specialised, lots of logistics. How will the cars move around the site? Where will you put your plant so you can make as much throughput of the cars as possible? A bit like the turbines with the wake and how you put them. None of the cost of constructing that specialised site is allowable because it's not itself part of the plant. The plant is just presumably it was the car wash or whatever. But yeah, not allowable. And because there's no special rule for premises or money, it's just the fact that they're not plant, if you like. The class is not closed about these other things it could be on. It could be intellectual property. It could be goodwill. It could be on something as sort of nebulous as maximising your profits. It could be on a business management plan or a business model. There's all sorts of things that aren't on plant, and even though they help you make good choices about your plant, they're not on plant. And I think those sorts of cases are where actually the idea of remoteness is quite useful, because you just know it's too remote, and maybe the thing it's on is a little bit more nebulous than the setting or premises because it's a business model or it's optimizing your profits. But I'm that revenue are not setting up remoteness as a separate test to the word on. It is part of the statutory test of whether it's on or not. But it's really, I suppose, elucidating it all. It can be a helpful way of expressing why it's not on the provision of plant. And to that extent, we accept what the Upper Tribunal say. It's not a timing point. It doesn't matter that you incurred an expenditure 10 years ago. Oh, so it must be too remote, it can't be on. Although it's likely in the real world that if you spent it 10 years ago in the startup of a new business, it is not on the plant. But it was never our case that it was a timing point. It's a helpful way of understanding whether something's on or not, or expressing it. And perhaps just now, if I could just clarify a point. So I wouldn't accept that you begin with the actual plant, and because you've got the actual plant, it's then you can then just look back in time, trace through what you happen to actually spend, and so long as you've got some sort of link, you're allowed the expenditure of all of it. It still has to be on the provision of the plant. The effect of the expenditure has to be the provision. So you have to decide what provision means. And what the tribunal has said is it's the supply for use. And the paradigm is buying a ready-made thing. And that kind of gets your feet on the ground as to what we're talking about. That's the supply for use. And that's why constructing it yourself is allowable, or fabricating.
I wonder whether you are actually attaching quite a lot of significance to the plant, aren't you? In the sense that you say, well, you have to look at what you end up with. It's only when you know what it is you want that costs become relevant. So it's not just the significance of the word on the provision of, in a sense. It's you have to know that it's this thing you want.
Yes, because the idea of a supply for use is that an item is being plant is always a tangible item.
Yeah.
This tangible item is being provided, and in the business you've got your cooker, and so you say that cooker, I've incurred all this different kind of expenditure. One was on interior design about what colour I might want to buy if I whatever, and then the other was, but then in the end I paid the price, I bought it, and I got someone to come in and they installed it for me, and that's what's allowable. I am now going to go through the.
So you're suggesting this is a convenient.
Well,
break.
it might make more sense than
Yes.
doing. I'll start with Buckley Kerr.
Yeah. So 2:00.
Court rises